in the firm's complex litigation and dispute resolution group, where she concentrates her practice in areas of high-stakes litigation, corporate law, and international arbitration. Gaby has an impressive legal career, practicing for over 25 years. She started clerking for federal judge Sagel in the Northern District of Illinois, who passed away this past year, and went on to work for the international firm of Kirkland and Ellis, concentrating in Latin American commercial disputes. While at Kirkland, she was seconded to work in-house for Colgate-Palmolive Company in their Latin American division before transitioning to a global accounting firm, Grant Thornton, as managing director and special counsel on risk and public policy handling, a variety of matters beyond litigation to include trademarks, compliance, and contracts. We also have Jorge de Neve. Jorge is a partner at Melveny and Myers, specializing in corporate investigation, securities enforcement, and securities litigation. Jorge was previously an enforcement attorney with the U.S. Securities and Exchange Commission. He represents public companies and financial institutions in investigations by the SEC and shareholder litigation. He represents investment advisors and broker-dealers in the FINRA Arbitration Forum, has represented Mexican clients, among others, in litigation and arbitration matters in the U.S. Last but not least, we have Marco Molina. He's a trial lawyer at Baker Hostetler, who focuses his practice in international disputes. He represents both investors and states in international investor-state arbitrations. He also specializes in international commercial arbitrations, cross-border litigation, global asset tracing and recovery, anti-corruption compliance, crypto-related litigation, corporate governance, and extradition cases. He has represented clients before U.S. federal, state, and administrative courts, before the ICSID, the ICC, AAA, and affiliated International Center for Dispute Resolution. He's a member of his firm's Latin America practice, who has tried cases in English and Spanish, also proficient in Italian, and making a reference to another interesting Netflix documentary, if you're into that, Bernie Madoff related. He is a senior leader of the team working as counsel to the court-appointed Securities Investor Protection Act trustee in the liquidation of Bernard Madoff Investment Securities, LLC, and he's chair of the Foreign Discovery Committee that advises that team. So that's it. Gaby, you want to start telling us about, well, with this panel is about international arbitration and mediation, but why don't you tell us about what the business courts are, the options, and how they are available and can be helpful?
Okay, so how many of you have heard about the new Texas Business Court? A couple of hands up there. Okay, so typically when you're looking at an international, situation where you've got multiple people, when you've got multiple companies and entities working together, joint venture or any sort of enterprise that you've got, you often have to think about, well, do we want to include an arbitration provision? And now, you still can't hear? Okay, so so the typical question is, do we want to include some sort of arbitration provision in our agreement and contract? And now a lot of courts, a lot of states have enacted what we have coined business courts. And Texas is probably about the 31st state to actually think about this and pass legislation to create what they coined a business court. And it's a sort of a loose nomenclature because it really doesn't necessarily establish a separate court in some instances, and it's not one size fits all. So what you have is basically a set or a program or a docket, some sort of system that states have enacted and put into play as an option to deal with some of your more complicated, complex litigation cases, particularly commercial cases, to give you sort of a viable option between arbitration federal court, and then the usual state court, situation. Oh, okay, great. All right, well, we'll try to do this way. So anyway, if it works, let's see. Well, maybe not. Come back, Otane. Oh, you might have to, okay. So really, yeah, that's perfect. All right, so the courts really came, they started in the 1990s, and one by one, they've sort of come about. Like I said, there's no one size fits all. Now there's over 30 courts, 30 states that have enacted a similar type of system or court system. The common goal seems to be to get commercial business disputes resolved as quickly as possible, and also to get or develop at least a well-rounded set of laws and rules that we can all kind of anticipate and contract around. So what I've seen is now, from all my readings and what's going on here in Texas, is that they're really focused on a couple of things, probably rightfully so. One is, how are we going to select our judges? What's the proper way? Is it going to be elected like the Constitution, at least of Texas, requires, or is it going to be okay to be appointed? They also are looking at comprehensive rules around e-discovery, which, as you know, is if you don't, if the law, what was I told? If the law is against you, argue the facts. So the facts are against you, argue the law. And if both are against you, argue discovery. So that's basically the rule, right? And we know how complicated that can be today with text messagings, social media. We're all looking at, we're going to talk about a little bit later about IA and some possible benefits for that. So, and then also, everyone wants to focus on remote proceedings and whether or not we're going to have to require written opinions by courts. Because, in arbitrations, that's usually not the case. So it's very difficult to actually, get some kind of predictability in an arbitration proceeding unless you know the arbitrator. And so anyway, that's kind of the basics of it. And I did a little bit of a research, and this is pretty much the state of the law right now. These are the states that enacted them in the 90s. Everyone knows about Delaware. They consider that to be the, some call it the very first business court, but they actually separately have a separate court system that deals with complex litigation and business cases, and that was started in the 2010s. And then Texas is the last one. So I think we're almost at 32 or so. So that's where it is. Well, yeah, this one, for Texas, the law actually became effective September 1st of this year. The goal is to have the courts operational by, next year, September 1st. So that's a pretty lofty goal, given that they haven't come up with rules yet. They're working on it. They've got a subcommittee that is meeting, I think, almost weekly, bi-weekly, to kind of craft what those rules are going to look like. So we'll see what happens. So one of the questions that has come up is what exactly can this court hear? And one of the things keep in mind is that they're calling it a single court because it has statewide jurisdiction, but there are actually going to be different divisions, and certain ones are going to be operational by the end of this year, and some will be operational later in the year. But in Texas, at least, what they've decided is sort of put cases into 3 buckets. And the first bucket are the cases that are above $10 million, and those they'll be able to hear any qualified, monetary transactional cases, any cases dealing with contracts or commercial transactions where the parties agree, which comes into play again, how do you contract for this, and also for violations of the Texas Finance Code and Business Code and Commercial Code. So that's kind of the first bucket of cases that will fall under their jurisdiction. Now again, it's concurrent jurisdiction, which means someone can file in state court or in federal court, and or they can choose to file in this new business court. You also have a second bucket of cases, which are those that are $5 million and above, which are your, what I consider the corporate law or governance type of cases. So you'll have derivative actions, corporate governance disputes, dealing with owners versus owner disputes, securities, breach of fiduciary duty cases, you know, and general Texas Business Organization Code cases. So you do have to meet that jurisdictional threshold in those cases. And the other category, the third bucket, is really sort of a side bucket because what they've decided is that if it involves a publicly traded company or you're just seeking some sort of equitable relief like injunctive relief or declaratory relief, then you don't have to meet that $5 million threshold. So that's basically the lay of the land. There's also supplemental jurisdictions, so this is getting to be almost sounding like you're in federal court, right? You're gonna have those battles with removal, venue, jurisdiction. Now you've got also supplemental jurisdiction by these business courts, which means they can take in other related cases as long as they're part of the same controversy or case, and all of the parties agree. So you could be in a predicament where you're litigating the main case in the business court, but the parties don't agree or the judge doesn't agree, and you've got your related cases pending in a different court, so which could get complicated, right? So how do you deal with that? I do have a couple of other slides that show you the types of cases that could be brought in under supplemental jurisdiction. So you've got, you know, liens, covenants not to compete, consumer transactions as well, property code cases. So there's a lot of categories of cases that could be swept in. And then there's just, if you go to the next one, there's just some things that they said, nope, we don't want it involved. We don't want you to bring it here in the business courts. And those are the medical, you know, and legal malpractice cases, personal injury or death, and insurance coverage case. So they don't seem to want to touch, I think, other areas that are already heavily regulated and have other different types of procedures to, you know, kind of quickly deal with issues. Yeah.
Okay, thank you. So let's, Jorge, once having talked about or learned about the business courts, now we get into arbitration. And as a non-litigator, corporate attorney, when drafting contracts, there's always a question of whether arbitration or traditional court dispute resolution. So usually arbitration was supposed to provide cost savings, advantages over litigation, which some say it's no longer the case. So why don't you give us your thoughts about that to rank the cost of arbitration, the time, the lengthiness, et cetera.
Sure, I'd be happy to do so. And make sure I can be heard. And I think one of the things that you are seeing with like the business courts is kind of an effort to try and come up with a more economical way to handle the disputes. Some of that I think can be done through arbitration, though I think a lot of businesses would probably indicate that from their experience, arbitration is not really any less expensive than litigation many times. And I think a lot of that really is driven by one principal factor, which is really discovery. And basically, the idea of setting up rules at the beginning, in other words, when you are contracting, that's going to be able to limit the discovery that goes on later. And part of that may be simply being aware of what are the set of rules that are out there. Because I thought about it realistically. Yes, from the litigation side, you would think, wow, why don't you just tell them what the rules are going to be? But are you going to really have an appendix of rules in a contract for arbitration when everybody at that point is really more focused on the deal? But there are entities that have put out rules. Obviously, once you identify whether it's the ICC or or JAMS or whatever group that's gonna do the arbitration, they will tend to have rules, but those aren't necessarily rules that you have to completely adopt. And one of the options could be, for example, to make sure and limit the what I view as more of the U.S. based type discovery functions. So just, you know, there is the possibility of doing depositions. Well, how do you cut that down? That actually is going to save a lot of money on the arbitration. That said, you know, it's always, once you get to the arbitration, there is somebody that doesn't want those type of things to happen. It usually means there's somebody on the other side that feels like, how come we can't do this, right? So it's also kind of letting clients know ahead of time, right at the beginning when the contract is being signed, what's going to be the impact of doing those type of things. The other thing which was interesting to me in terms of especially handling Mexican clients is even some of the concepts of document discovery, producing documents that you aren't necessarily going to rely on, was surprising to some of my clients, because that's just not something they're accustomed to. And so it's also getting them more familiar with the idea that, you know, even arbitration is going to potentially be, international arbitration is going to be broader discovery than what you might have in the Mexican judicial system. The other thing which I think is worth talking about, I was talking to Jorge de Hoyos yesterday, and he mentioned that the concept of mediation, of trying to resolve something ahead of time, is not something that has been, I think, valued necessarily in Mexico. But that may be an area where, yes, it might add cost, but it's also kind of potentially a way to try and resolve things before you get to arbitration, and maybe starting the discussion about that during the contract phase, where you put in some clause that will require going to mediation. And assuming people, you know, once you get to the litigation, assuming people are being a little more rational and maybe it's not as emotional, it's potential that mediation could help in terms of cutting that down as well.
The interesting thing is that some of these courts that have created business courts have included ADR as part of the process. So they'll automatically send certain cases to ADR to try to speed up the resolution. And some of the statistics, I think it might have been Georgia mentioned that, it cut down about half the resolution, the number of cases that kept pending, it cut it back down in half. So it was having a positive effect and impact, and maybe that's why we've seen about 30 states pass similar business disputes courts.
I do have to say that no dispute is, not all disputes are created equal. And I find like we do this a lot with general counsels, where we really sophisticated people, they're really good at their job, but then you ask them, what's your dispute resolution clause? They say, well, we copy and paste the same one that we use for all our contracts. We use them, and it's worked out fine for us so far. So, well, that could be, but for instance, I know with international arbitration in the commercial context, ICC is king. That's what people know. That's what people default to, and ICC is great in many respects. ICC is also extremely expensive. The default, if you can't agree to a place to have the arbitration, it could be you have to go to Paris, which sounds great, but the clients don't always agree that it sounds great, because they have to pay for the arbitrators to be there for a week, they have to pay for your lawyers to be there, for the witnesses to be there for a week, and it adds up fast. So when you start,
and there's usually 3 arbitrators.
Right, and there's usually, and they like to eat, at least 3 meals a day, maybe more. The point is that there's a lot of times the dispute is you're talking about a $5 million, potentially a $5 million case. It doesn't make sense to have 3 arbitrators in Paris, resolving this dispute. These are things that you can get ahead of. And I think a lot of us in this room, it's something that whenever I do this presentation to general counsels, it's always seen as, this is great. I never thought of it that way, because the reality is when people who tend to draft those clauses aren't thinking about what's going to happen 5 years from now when we're all in arbitration. They're thinking about the other clauses, which sound way more interesting and fascinating to them. So that, unfortunately, we're like the bearer of bad news. With going like, well, but if things go south, you want to think about these issues. So, anyways, I fully agree with what my colleagues are saying, and I think that this is a place where we as arbitration practitioners can do more to educate our clients, because even though international arbitration is now very commonplace and well known, it's still, to a lot of people, it's still sort of this unknown, and then later they find out, they signed up for more than they could chew.
And one of the things I want to add, just in terms of the number of arbitrators, I mean, there is at least a study out there that would indicate in FINRA arbitrations that 3-person arbitrators actually produce more extreme results than instances where you have 1 arbitrator. Now, I haven't studied the study to see, if it meets all the necessary standards, but there's some theories as to that, and so that's something also to consider. Most people think 3-person arbitration panels are going to give you a more in the middle type result. It may not be the case.
Although, I mean, speaking about FINRA, I have a FINRA arbitration right now, and they literally served over 100 discovery requests under the pretext of discovery of requests for information and documents, and it was just a whole fishing expedition. But it was one of those things where you have to kind of respond to it, but the response is, this is not appropriate. This is beyond the scope of what's required under FINRA, which I kind of like the FINRA rules actually, because there's a set way of producing documents and a set way of producing information. It's pretty close to the time that you're going to have the trial or on the case, and you produce what you're going to use. And I feel like there's a lot of wasted time reviewing documents and people use it as a strategy to inundate your client with, just trash, basically, that you have to still sift through, and AI is not exactly the best at sifting through that information today. It helps, but it's not great. I mean, you could get 50 documents at the same email, but just slightly different formatting, and it won't pick it up.
Yeah. I mean, especially if you're not, with FINRA, you're kind of stuck with their rules. So generally I like the FINRA rules because it's limiting somewhat. But, I know, for example, I believe the IBA has rules that put the burden on the person that's asking for the documents as to what it is, to justify why they're asking for it. And that little thing, you think, well, they'll do it anyways. But a lot of times people will now the expense is on them. And so potentially that might limit some of the requests that are coming out.
But the arbitrators don't tend to like to say no, I found, on discovery disputes. And that makes it difficult, I think.
It also depends on where they're from. So it's very common for me, what I do, to be in front of civil law attorneys, civil law arbitrators, who just view discovery as sort of this weird, thing that they have to kind of go through, but they view it as very limiting, and they're far more willing, I think, to take on a defense that I think a U.S. judge would give the back of the hand to. And so that's one of the things with international arbitration. You sort of get who you get, and they come from where they come from, and sometimes that's amazing, sometimes not so much.
But that's also an argument for having more than one arbitrator.
Yeah.
Because you tend to pick one that's more like-minded, right? I think that term was used today. Somebody is more like-minded with your client, and then they pick someone that's more like-minded, and then they have to together pick that third one, and that's where hopefully there's some reasonableness that comes into play.
So taking a step back, Jorge mentioned clauses in agreements, and Marco was on point saying that there's not really like a one-size-fits-all clause or arbitration structure for an agreement. Can you guys speak for a minute or two about, in your experience, in the context of cross-border contracts, transactions, maybe not for the billion-dollar deals, but good size that deserve a well-planned and studied arbitration clause? What do you recommend in terms of number of arbitrators, the body, whether ICC, pros and cons? What do you recommend for a practicing attorney drafting contracts? Gaby, if you want to start.
I guess it depends on what side of the coin you're on. You're for, right? I think that if you are the bigger company and you're dealing with a smaller, vendor, that you probably want to make it difficult for them to actually institute some sort of proceeding, and you want to lock them in for an arbitration because it's very expensive. I had a construction case potential, and the client was like, okay, we need to collect this money, and I drafted the whole arbitration, petition, and at the end of the day, it didn't go anywhere, right? So it just depends on where you are. If you want to prevent them from doing something, I think arbitration clause like a AAA is fine if they'll take it. I think sometimes it depends on how sophisticated the other player might be, and how serious it is. I think you can craft it in a way that there's a threshold amount that's in dispute, and if it's a certain amount, then you can trigger certain rules, and if not, you trigger other rules. I think mandatory like mediation is probably a must today, just because I think e-discovery can get so crazy that it'd be almost malpractice not to suggest that.
Thank you.
Sure. So as I mentioned earlier, I think the first thing you look at when I get this question is, okay, what's the dispute amount likely to be? What's the range? That already tells me whether you should be, if it's less than 10 million, you would think a one-person tribunal would be the way to go. When you're talking about tens of millions of dollars into the hundreds, 3-member tribunal makes sense. I think also you look at the subject matter. Gaby just mentioned construction disputes. I think for construction disputes, my recommendation is have built into the dispute resolution clause some sort of a negotiation between the heads of the project and maybe an independent engineer, which is a common clause you see in those types of contracts. You look at the law governing the contract. If it's New York law, I tend to recommend for smaller arbitrations, international arbitrations where they have U.S. law. I tend to recommend the CPR. I don't know if you're familiar with it. It's the Conflict Prevention Resolution Institute. It's got a lot of U.S.-based or U.S.-trained people who tend to be appointed. So there's a million considerations, but most of what I do too is sort of say how things could go wrong. And I think again, I feel whenever I do that, I have people stop me and go, wait a second, you mean I could pay this much or this? I'd show them what ICC arbitration costs look like, and the calculator that comes with it. So that's usually what I do.
Yeah, and I think that's a great idea in terms of laying out what the cost could be kind of on the front end. I mean, I usually have dealt with it in the back as opposed to actually during the drafting process. But it really does appear that a lot of clients are surprised about something with respect to either the cost or the discovery or lack of discovery. And even if they think they should get more discovery, they still don't like the cost. But it's those type of things where at least to provide some understanding on the front end so that they could make a decision as to what level of risk they're willing to take with respect to what the arbitration might look like.
I just put up there, I happened to pull that, the latest sheet on the AAA and international filing fees, just so you could get a feel for what kind of the numbers. They go to 10 million and above, and then the initial filing fee. I mean, it's insignificant if you're thinking about millions of dollars, obviously. But it depends, again, who are you up against? Who's the, if it's a vendor or another smaller, that would be a significant amount of money to prevent them, at least from filing something that might be frivolous, that they're just using to leverage you to get a better deal, for example. So.
Thank you. So this is one of the reasons, this question that I'm going to ask, this topic that I was really excited and looking forward to it. The conference has been all about the buzzword being nearshoring, right? But we're going to talk about artificial intelligence, AI in arbitration. So Jorge, Marco, tell us about it.
So just, we'll do the show hands thing. Who here uses artificial intelligence in their disputes, whether it's litigation, arbitration? All right, I guarantee you in 5 years, almost every one of you will have your hand up. You know, we're creatures of habit. We don't like change. We like our practice. We like how we do things. That's how we grew up doing them. But the reality is technology keeps evolving, and it's not a matter of if, it's a matter of when. And it's not because we want to change what we do, but it's because our clients do. Because they realize that there's a cheaper, faster, more efficient way of doing things. And so I'm gonna give you some examples today of how I've seen in the day-to-day some of the artificial intelligence software and systems that we use. So, you know, I think as an initial matter, let me start with ChatGPT, because that's sort of the one that I was talking about. So let me tell you a funny story. There was this study where, and I wasn't involved, but I know somebody who was, where they were feeding ChatGPT with information, you know, case law opinions from U.S. Court cases, and then the idea was that after the computer was ready, they asked it, you know, find me the case that goes to this issue, and so then and write me the brief. So the ChatGPT goes ahead and writes the brief, and cites to this case law, and references the name of the case, the court, the year, and goes through and explains the holding, and it's dead on. Except the problem is ChatGPT made up that case. It never existed. And so this isn't perfect yet. ChatGPT isn't, I don't think, and no one's proposing that today you could have or should have anyone drafting something through ChatGPT. There's a bunch of ethical issues there from a practitioner perspective. We have an obligation to get it right on behalf of our clients, so delegating things to a computer and hoping for the best isn't the right approach. But where we're starting to see it is we're starting to see it in the pre-arbitration stage. So there's this thing called ODR, which is online dispute resolution, which a lot of internet companies like eBay, PayPal, already use, which is similar to what we were just talking about. You know there might be a dispute. Rather than go to arbitration, once you start arbitration, you know, defenses go up, costs started getting incurred. There's AI systems in place where it's not perfect, but you can essentially submit your dispute to this AI, and it will just like a mediator, it'll tell you what some of the strengths and weaknesses are. And you know, and sometimes maybe that's what a party representative needs, to take a step back and say, you know what, maybe this isn't worth it. Maybe I need to go back and negotiate a settlement. Maybe we need to take our losses and keep going, or maybe it confirms sort of suspicion that you might have a case. So we see it in that context. We also see ChatGPT starting to come up in international arbitration. For those of you who practice international arbitration, you'll know the worst part about it is how long it takes to get a decision. I'm working on several cases right now where it's been more than 2 years since we've had final hearing, and I still don't have a decision. A lot of it is because these international arbitration tribunal members tend to be flooded with cases. They don't have enough resources and staff to be able to sort of catch up. So one solution that's been proposed and adopted by some is, why don't we have ChatGPT or some similar AI draft the parts of the award that are not really in dispute, the procedural history, some of the background. That's not something that's going to resolve the case. It's just literally laying out what the arguments were or what the proceedings looked like before the award. That's something that will save time, save costs, and move things along. So as far as ChatGPT, I guess the long and short of it is we're not there. The thinking is that in the future, you will get, the technology will be good enough that with human, oversight, you will have things written and presented in international arbitration matters that are mostly drafted by some sort of artificial intelligence. Again, we're not there yet, and there's a lot of other issues that come with that, like I mentioned, ethical issues, regulatory issues, et cetera. I see we have a 10-minute. I'll say one other. I mean, I could talk about this topic all day, but I don't want to bore you guys with it, and I also want to give my panelists time to discuss something else. But the way that I see it, that where I use it every day now, is translation services. I for those of you who do international arbitration, it's very common to be in a room, to be talking about your co-counsel in one language, your client in another language. You'll hear the testifying witness that day is testifying in a third language, and then the tribunal members, they understand a fourth language. And so you have a lot going on. And what happens is with all that dynamic is inevitably people are human, so translators won't translate correctly. The transcribers, the court reporters will not transcribe something correctly. And then you're stuck with a record that, despite the fact that everyone tried their best, it's just unwieldy. What I'm starting to see now is just today, if you gave me something in, 2 years ago, if you gave me something in Spanish and you said, can you immediately get this, translated through Google Translate? The answer is sure, but it's going to be terrible. I mean, I'm going to have to go in there and spend just as much time fixing it than had I just translated it myself. Nowadays, for those of you who use Microsoft Word, there's a translate function in there, which is 10 times better than Google Translate, which happens instantaneously, and you can do entire documents in a click of a button. Still not perfect. We're getting there. For what I do, this saves me a ton. I mean, every day I have to translate something, and so I see it happening, and I see it taking over our practice, and mostly in a good way.
Yeah, I mean, and I would say with that, I mean, that's part of a lot of times the way to reduce costs also in arbitration, because the translations can start to add up. And so that's going to be helpful in that regard. One of the things, if you're doing litigation, and I was one of the persons that did not raise my hand, but stuff like technology-assisted review is basically AI. So, a lot of us that are doing litigations, arbitrations, are using AI in terms of doing document reviews.
So interesting. Thank you. So as we get into the final stretch, Gaby, going back a little bit to the business courts and linking it to the option of arbitration or mediation, then arbitration. Some final thoughts of what do you recommend to your clients? What's you have the business court option. We didn't get into much detail, for example, about appeals, where do they go, if there's any other considerations to take into account for a client that may be a better choice. What do you do? Do you, in some cases, business courts, in others, ADRs?
I think first off, whenever you're drafting a contract, you need to take a look at where ideally you would want this to be resolved, right? So venue is going to be key, and you need to see whether or not wherever that is, there's an option for a business court, right? For example, in Texas, it's supposed to be operational, but it's only operational in 5 divisions, so 5 regions, which includes, the major cities, but not the other cities. So what do you do if you've got a case, venue is proper in, I don't know, Hidalgo County, and there is none there, and I don't think there's plans to be any business court there. Can you file it there? And if you do, will it be removed? So you've got a lot of issues that you want to, I think, contract around. So I think it's going to require you to really think through kind of, what my colleagues talked about is what will the potential dispute be about? What's the potential amount of that dispute? And then take a second look at that arbitration provision, or take a look at whether or not there is one, and maybe, if the parties agree and you write it into the contract, that is definitely an option to resolve it in a business court. And like I said, the rules aren't made for Texas yet, but I do envision them having some pretty precise rules about e-discovery, and that's going to be, I think, key to resolving any dispute, because that's where the money is.
Yes. So Jorge and then Marco, again, as closing thoughts, we didn't get that much into detail about discovery and gathering evidence within the conversation of selling it, or the advantages of arbitration, and maybe clients or companies not seeing it as an ideal cost or timeline. What are the challenges? What can you tell us as closing thoughts on that?
And I guess what I would say is some of the challenges is that really are that a lack of understanding of what happens when you get there, you know, and whether it is, I mean, I've had clients that were shocked that they have to provide so much material. I'd have clients that want me to file motions because they're not getting enough material, right? So, and part of that is just making sure that they understand the process. I don't think that'll ever change because ultimately that's kind of driven by the dispute, but it's kind of understanding that process early on. And I would say the other thing is just the idea that even if you decide that you want a certain forum, doesn't mean that you have to necessarily take those rules that are completely there. It is contractual. And if you decide that you prefer the CPR protocol but want to be in the ICC, well, you can go ahead and structure it potentially that way. And it may be easier to do it because you're not necessarily discussing with people, you know, the particulars of the rules. They can go ahead and look at it, and it might be something that could work.
With respect to evidence, I feel that most people don't do enough, or are not. I feel there are so many options when it comes to when you're in a dispute and where you can benefit your client. If you need discovery and you're not getting it through the normal discovery processes within there are ways to go. Just to give one example, this happens a lot in my cases where we are either up against a government entity or representing a government entity. Most governments and most Latin American countries, like Mexico, will have transparency laws, or laws where you know, essentially the equivalent of FOIA in the United States, where you can make a request under those laws, domestic laws, and obtain documents from the government through these public disclosure mechanisms. You know, it's something that everyone knows about, but it's rarely used, and we've used that in arbitrations. And whenever someone complains, which happens, governments complain, go, hey, well, you're not supposed to have that. We're like, it's your law. You know, we just followed your law. There's 1782 actions, which I know the Supreme Court has said don't really apply to some international arbitrations, but there's still some question as to ICSID cases, for instance, although that might get decided. There's MLATs, there's Hague Convention and taking of evidence, and there's also just straight up hire an investigator, pick up the phone, talk to witnesses. You know, we talked about the Madoff case. We've to date recovered more than $14 billion for the victims. And the question when we get, you know, how did you do it? Did you follow a certain patterns? We tried everything. And I can't tell how many times I cold called people and said, hey, you know, I know it happened a while ago. I know you don't want to talk to me, but we're trying to help the victims. Can you see if you can stay on the phone? And then that one conversation leads to one lead, and then you follow that lead. So all I'm saying is that I feel there's this, rightfully so, there's this stigma with international arbitration if you're a U.S. lawyer that it's more limiting, and it is. But it doesn't mean you need to stop there. There's ways that you can, you know, add value and help your client.
I mean, the one thing I will also add to that, I mean, criminal attorneys in the U.S. don't get discovery in great amounts, right? So they have to take those steps. And even just internet, if you do internet searches, you'd be surprised at some of the stuff that's found there. And I think a lot of attorneys think that they kind of have to follow the discovery rules, and it's not the case. So I think that's a very good point, Marco.
I've used the CIA before. Just saying. There are ways.
Great. We have a couple of minutes. I don't know if anybody has a question or wants to share or compliment something from their experience.
What's the average duration of the national arbitration process? How long, once you get the award, how long does it take you to enforce it before a national?
Yeah,
Great question. I would say that international arbitration, if we're talking about a commercial case, I'd say 2 to 3 years. I mean, it depends, right? But typically, I'd say to a client 2 to 3 years. If the other side doesn't pay, which is happening more and more, I don't know about domesticating it or enforcing it in the Mexican court. I can tell you in a U.S. court, we have the Federal Arbitration Act, and we have the New York Convention, and where we are able to domesticate arbitral awards rather quickly. There's certain tests that you need to meet, but they're usually met, and so. And unless there's some flaw with you could get domestication and then execution in the U.S. in a matter of months, not years. And oftentimes, because these execution proceedings, these enforcement proceedings, have U.S. discovery built into the procedure. So that means that if you're not sure where the assets are, you're able to use depositions or document requests to be able to find the evidence that you need to be able to find it. So it's definitely happening more and more where people aren't paying, but I still think that in the U.S. at least and in most countries, it's rather easy to enforce.
Yeah, I think we could have another conference or panel about just domesticating arbitration awards, right?
Yeah.
Anybody else? I think it makes sense, right? 1782 was supposed to be states helping each other out, and what the Supreme Court said is if it's commercial arbitration, you're not really helping out another state's administration of their laws because it's a private contract. So that makes sense to me. And then they also said that doesn't apply to ad hoc investment arbitration. Similar thinking there. There's no state involvement. But I think it hasn't been tested at the Supreme Court yet. But I think ICSID is different because ICSID is the investment where most investment disputes are filed. And ICSID is governed by the ICSID Convention, which has been adopted by the member states into their domestic laws. So a tribunal that's organized under the ICSID Convention is essentially being organized under the laws of a state. And so I think that when you look at the Supreme Court's analysis, while it makes sense, selfishly, I don't love it that I can't do 1782s for commercial arbitrations because it used to be really helpful. But I think it makes sense, and I'd like to see the Supreme Court take on the ICSID issue because I think it would be different.
Just a word of caution about ChatGPT or any other public internet AI that you might use. Most states are ruling that waives attorney-client privilege if you're using anything that's public, not your own private AI.
Yeah, there's a lot of regulations going to have to take place before it becomes commonplace.
I mean, that's a potential issue also with Google Translate, by the way. So.
Okay, it was great. Thank you so much. Thanks, everybody.